I'm Dean Corsack, the legal director for Rome Research Site and our laboratories. And thank you to the Griffiths Institute for hosting this. And here you go, the disclaimers. So nothing in this presentation constitutes federal endorsement of non-federal entities, financial, legal advice, or the official position of the United States government or Department of Defense or the United States Air Force or our clients or employers. So what do we do at Rome and why are we having this presentation? It's arrows here. What percentage of our acquisitions went to small businesses last FY? 45% of $1.5 billion went to small businesses. But guess what? This will be the favorite statement of the presentation, Heather. Are those small businesses going to stay small?
No, they're going to grow.
They're going to grow. And so Rich is a partner at the law firm of Womble Bond Dickinson, but I was stationed in Huntsville at Missile Defense Agency years ago, and he's started out as an Army JAG, but developed decades of practice working with companies with federal contracts, and then those small companies that grow encounter the mergers and acquisitions challenge. So sometimes they grow not organically by hiring people, but by acquiring other companies or merge. And there's a lot of special rules that go with that. So thanks for being here. If you have questions, you can ask them. I'll bring you the mic. We have some online folks, so if there's a way to submit a question, that's great. I wanted to mention one more thing that's kind of unique about Rich and his firm is they do specialize in cybersecurity issues and helping companies comply with federal requirements, and then a lot of the other aspects of information management that are getting kind of complicated. And then I'm pretty sure your firm claims to be the first law firm to ever have an internet website. They appreciate technology. So thanks for being here, Rich. Over to you.
Thanks so much, sir. Appreciate everyone being here. I want to try to answer your questions. So please do, as I'm going through, raise your hand if you have a question. If it's something I'm going to cover later, I'll let you know that, and we'll try to circle back to things. Hopefully we'll have some time at the end to answer some questions. I hate to load up on disclaimers, but I have some of my own that I have to make. The courts and jurisdictions that I practice in want me to tell you that I can't represent that my legal services are better than legal services of anyone else. And guess what? They can't say that either. So, you know, we all start with that initial disclaimer. I do a good bit of work in the government contract space. As the Colonel mentioned, I started my career as an Army JAG officer, and that's where I sort of picked up things. So this is me, and you have that information. And this is what my firm does in sort of the government contract space. It involves the startup, the formation of the company initially, dealing with small business and size issues, SBA problems, teaming agreements, joint venture agreements. Small businesses frequently team, as you know, with others to go after opportunities. So all of these sort of things, advice with cybersecurity and IT. I don't do all of those things, but we have a group of attorneys that focus on global solutions and work in this industry. ITAR, export control, a lot of the technology has those issues. So this is kind of where we're going. My hope is to give you initially some sort of background information on mergers and acquisitions, generally, also how the market is today with respect to some GovCon purchases, and then focus on some of the particulars that pop up as a business either purchases or sells in this industry, and I'll try to save room for some questions. So mergers and acquisitions, or M&A, is really just the buying and selling or transferring of a business. Presently, we're seeing a lot of government contractors, owners who have started their business, have grown, built up value, and are either selling to large businesses who are doing some sort of strategic acquisition or merging with other businesses or buying other small businesses themselves. And sometimes that's for a particular opportunity, particular contract. Sometimes it is part of an ESOP, an employee stock option plan, where essentially the employees are starting to have ownership in the business. Private equity is something that we'll discuss more in a second. So, you know, this is private equity activity. People, investors investing in businesses, parking their money somewhere, buying up government contracts businesses. And the data at the end, it was 2022. As of June 30th, it has gone up. So we've seen this climb pretty consistently over time. And, in terms of who is doing the buying, there are strategic buyers. A competitor sees that a small business has an in at a particular agency or has a particular contract. Maybe they're doing the government contracting involved with cyber security and the rollout of CMMC 2.0, and they want to get in that area. So they pick up somebody there. Could be a consolidation. Could be a financial buyer, private equity I mentioned. It could be related buyers. So, the president wants to sell and some of the stock to the vice president or others involved who are coming in. So different types of purchases and sales have sort of different goals and things involved there. This particular slide sort of gives you an idea of what the M&A industry or area considers large, middle, and small in this government contract space. So large, around 2,000 companies, the revenue is 1 billion and up. And then, for each one of them, it talks about a multiplier. So small, 5 million or less, and it says the valuation ranges between 2 to 3 times EBITDA, that is earnings before interest, taxes, depreciation, and amortization. And that's sort of a thumbnail rule in terms of a sale. It doesn't really tell you how much that business will sell for. What something's worth is actually what it sells for in the market. But it helps a potential seller to determine what the range might be for the sale of their company. In the past, we saw a lot of M&A activity with large businesses. Then it was middle. Now, really, there is sort of lower middle and middle is where a lot of the purchase activity is. So again, over 50% of transactions in the space are below 50 million. So the small business can provide a potential buyer for targeted access, potential intellectual property that's available, and other things that status, for example, in terms of small business awards. So all of those are sort of the considerations that go in when someone is trying to determine whether they're going to buy a small business. Again, the transaction multiples, that 3 times EBITDA, doesn't really dictate value. Risk is the biggest thing. So as we go through here, we're to talk about due diligence in this process of the M&A. And the true market value may depend on management, whether management's going to stay on in the purchase, whether the processes are set up in a way that can be continued after the purchase, whether things like if the owner has all of their kids' cars running through the business. These are things that could be cleaned up by a potential seller before you go to market. So with that background, the next thing I want to do is sort of talk about the anatomy of an M&A deal, and that is sort of the parts. This may be basic for some of you, but I will try to move through it fairly quickly. An M&A deal, a merger or acquisition, is a business transaction. Those can be very complex. A huge company merging with another huge company can be very involved. There can be OCI issues, organizational conflict of interest problems. There could be foreign influence and control, foreign ownership, influence, control, something we'll talk about later. It could be less complex. A small business, that is just being purchased as a strategic acquisition. Maybe that's not too difficult, but it still has considerations that one has to think of: affiliation, novation issues, things that we'll cover throughout here. So who are the players in this M&A? Obviously, there's the key business contacts, the owners and so forth, and the purchaser, the CEO of the buyer, of the seller. Investment bankers occasionally, it depends on where the money's coming from for the sale. Counsel for both, accounting firms, when they go through due diligence, there's going to be a lot of looking at paper, and the lenders, the bankers and their counsel. Usually where one of these deals starts is an NDA, a non-disclosure agreement, a confidentiality agreement. There's different names people use for this, but it's essentially, two businesses meet each other in a bar. Hey, I like you, you like me, let's talk more. Well, before you start showing everybody your numbers, you're going to want something to protect the confidential proprietary business information of your business. And that is usually a 1 to 3 year agreement, except for trade secrets that can be longer. But this is something that you would necessarily want to do on the front end. If it doesn't go through the prospective buyer, you don't want them to go out and hire all your employees that they met as part of the due diligence process. So there's usually a non-solicitation of employees agreement that goes along with this. So the next step after this non-disclosure agreement would be a letter of intent. So if things are getting more serious, we really think we want to start dating. We're going to put down certain parts of an agreement, a structure for how this might work. And it's going to involve a number of things that are going to be non-binding, but then there are going to be things that are binding. Non-binding would be, I'm going to buy you perhaps if these things might, work, and, a purchase might be around this amount of money, other things. The binding provisions are the ones that are important: payment of expenses, no shop provisions. So while we're talking to each other, we're dating exclusively. You're not going to others who might purchase you and talking to them. The confidentiality we talked about. Due diligence, I've mentioned a couple of times, and we'll go through in greater detail. But due diligence is I'm looking at the books and diving down deep into how you work to determine whether this is something we want to go through. And a termination procedure. So turns out it doesn't work out, how are we going to break up and what's going to happen with everything then. There are certain considerations with this letter of intent that I'll come to when we talk about small business affiliation concerns. So due diligence, I mentioned a couple of times. The buyer wants to identify issues or problems. We'll talk about some of those. There is usually a list that's provided. Data is provided through a virtual data room for the review. And that's where attorneys and CPAs start really diving into the meat of the thing. The deal structure, and in a future slide, we'll go into this a little bit more detail, but essentially there is an asset purchase, a stock purchase, or a merger. A merger is simply the two come together, and you can, they'd be called one or the other name or some other name as those two merge, but that is, two companies becoming one. And there's really no change of identity, although the government usually requires in a name change or in a merger some documentation and maybe a change through a modification on the contract. But otherwise, it is, they continue. Sale of stock is also a very similar thing. A sale of stock is, someone owns a contract or owns a business, and I purchase all of the stock of that. The entity is the same, and its identity never changes. So in that instance, there is no novation that's required. The contracts haven't gone from one government contractor to another. The entity stays the same. A sale of assets is different, and there's government approval that's required for that. So part of the issue with the structure of the deal is the fact that you can't buy government contracts. The government contracts with one entity and wants to know, this company is going to do our work. But we know this happens. So how does it happen? Well, in an asset purchase, it happens through a novation, a formal process submitted to the contracting officer to approve this. A sale purchase, again, is no change of the identity of the contracting business. It's just a stock change. So this is a little bit greater detail, and I realize there's a lot here on this slide, but the Anti-Assignment Act and novation rules are basically what I just described there. There's an asset sale, So the asset could be everything this company has that deals with working on this one particular government contract. All of the personnel, all of those assets would transfer. A stock purchase is just that. Purchase 100% of the stock of the company, and now you have a new ownership group, but the entity stays the same. And there's good and bads about each of these. An asset purchase, the con is you got to go through this approval process, and I'll talk more about novations as we go through this. But it does prevent you from having to deal with liabilities. Because you have just purchased the asset, you have left liabilities. All the workers' comp problems, all of the slip and fall issues, everything that former company, Inc. owned, it stays with them because you didn't buy the stock. You just bought this asset. Stock purchase is different. Now, you don't have to deal with the novation, and sometimes it's helpful to have a stock purchase because you continue with the size standards or the service disabled veteran-owned small business qualification of that, assuming the person that comes in and takes over can meet those requirements as well. But you don't have to do a novation with a stock purchase, but you have all the liabilities that go with it. So each one of these has considerations. I'm not a tax lawyer. I don't even play one on TV. So I'm not talking about tax considerations here, but there are tax considerations with each of these and benefits for each. So the deal structure, there's a purchase agreement. It could be a stock purchase agreement or an asset purchase agreement, depending on what's being done there. Usually the buyer's counsel starts with that and kicks it over to the other side, and then the negotiation begins back and forth. I like this provision. I don't like that provision. Negotiation of terms. But the type of transaction will often define what you need here. And then, there's issues that turn on the facts of the particular purchase. Is the management staying on, or are they selling and getting out? And if the owner who started this business and built it up and now has great value and is selling is proposing to retire, well, you don't want that person opening up a new shop doing the same thing the next day, right? So you're going to have a non-compete agreement as part of it if that's the case. The purchase agreement is where you allocate risks. You do due diligence, and we'll go through that process, but much of the purchase agreement allocates risks, whether known or unknown. It can be conditions for closing. We're not going to close unless these things happen. It can be reps and warranties, representations and warranties, promises that the seller is making. It can be indemnification. That is, if you've promised me that you have paid all your employees according to the Service Contract Act rules and it turns out you didn't, I'm going to come after you and you're going to have to pay me some of the money back. Could be earnouts. The seller is going to promise certain things, and if the company hits certain targets in the future, there could be more money that goes their way. So lots of different sort of structures and things that can go into the purchase agreement. It's not always cash. Yes, sir.
So the non-competitive agreement, is that for like a period of time or a particular area? You can't establish it in New York, you can do it in Pennsylvania, or is it a variable?
It can be a variable. It is a term that would be negotiated, and non-compete agreements are, that's an area that's in flux right now. First of all, most non-competes are governed by state law, so it can change from state to state. Generally speaking, non-compete agreements are more enforceable. There's greater enforceability if it is involved with the sale of a business. So just an employee who knows the special sauce at your company leaving, usually there's a reasonableness in time and geographic scope, as you mentioned, and some tie to a protectable interest. They knew the special sauce. They knew this confidential proprietary information. So there's got to be that, and it has to be reasonable in time and geographic scope. What I'm saying is most courts will allow a greater time if it is in the sale of a business. So you're spending a lot of money to buy this business. You can keep them out of work for a while. what we try to do when we draft these is to make them as narrow as possible. You know, you've got somebody who's, you know, built a business, is essentially retiring. Maybe you're going to keep them on for a period of time, and then they're going to retire and, you know, not go into industry. So they're 70 years old. You know, if you have a 5 to 10 year non-compete, really that's going to be enough in most instances. And that can be reasonable. And it could be potentially, it could be worldwide in scope as long as you draft it narrow enough to one particular thing. You know, quantum computing in a particular space. You know, I did a tour of this incredible facility today. So, I mean, if you draw the industry narrow enough, then I think it could be good. But time, geographic scope, and protectable interest are sort of the guidelines. So sometimes the buyer gives stock of its company as part of the consideration. In that instance, the seller will want to do more due diligence into the buyer. What's this really going to be worth to me in the end? There could be promissory notes and other things negotiated as part of the purchase consideration. So there could be purchase price adjustments up and down depending on you know, what happens. Adjustment done after closing. You know, there are various assumptions that you're making about what things will look like at closing. So the price can go up and down. Or as I mentioned earlier, there could be a buyout if the after sale the acquired company hits certain metrics. Then there could be an increase in money going towards the seller. And what you really want to do here is trying to make it as simple as possible to figure out so that you're not arguing over whether they hit those metrics or not later. Reps and warranties I mentioned earlier, and I'll go over some sort of government contract specific reps and warranties, but the seller is going to make certain promises that things are done a certain way. Hey, we paid all of our taxes, or there are no lawsuits pending, or, you know, we don't have any foreign nationals that have access to classified information. After, you know, after you start doing due diligence and looking in some of this, flags can pop up. But if you learn something after the closing, and this happened to a client of mine, you know, purchased the business, then DOL comes in and says, hey, you have misclassified this, the wage determination for these Service Contract Act employees. And so you haven't been paying them at the hourly rate they should have been, and the fringes they should have gotten. And buyer says, well, that wasn't me, it was those guys. Guess what? Too bad. And so they come out of pocket, and then the buyer has to go after the seller under an indemnification clause because of the reps and warranties, the promises that were made. So each one of those reps and warranties will have some consequences if they aren't true. So particular government contract sort of representations. Some of you may know about the False Claims Act. You know, when you sign your contract and when you submit a request for payment to the government, you're promising the government you actually did those things. Sometimes people don't. And there's some high-profile False Claims Act claims. So, you know, you don't want to be the buyer who later learns that, you know, they've promised certain things to the government and didn't do it, or that they've paid off foreign officials, paid bribes. So, you know, the reps and warranties deal with a lot of those things. Foreign Corrupt Practices Act, I mentioned. Some of the reps and warranties, you want them to identify contracts that are going to be, you know, require an ovation later. And so these are things that go into the purchase agreement in terms of reps and warranty. And the purchase agreement then sets up a framework whereby the seller will have to defend what it represented. And so, you know, there's general representations, what are called fundamental representations, and then covenants. And each one of these essentially is a statute of limitations for that promise. And hopefully as the seller, you know, you're going to put more of the things in the general reps. And really after a period of time as the buyer, you should know whether these things are true. Did they pay their taxes? Well, at some point, the IRS is going to come tell you they didn't. So after this period of time passes, the rep really doesn't, you should know after purchase, at some point that these are true or not true. So other components can involve the timing of the closing itself, the covenants, as I mentioned, conditions. There could be, for example, the actual closing or the final sale could be conditioned on the government consenting to certain things. Could be conditioned on financing, on legal opinions. Frequently in these things, one side or the other will require a legal opinion that the company was organized correctly. If it's an LLC, that these people who are listed on the ledger as having membership interests are the only people that had membership interests. Other components can be employee issues. So, the seller's concern about well-beings after the closing. Key employees, you want them to stay on. So what are you going to do? You're going to require the seller to put in place employee agreements that are going to keep them on, retention bonuses, non-competes, and so forth. So it covered some of this stuff, indemnification and what that is. Indemnification really takes the place of a breach of contract claim. The promises that go into the purchase agreement, whether it be an asset purchase agreement or stock purchase agreement, this is going to be the exclusive remedy for the resolution of issues between the parties. There are limitations that usually go into this. De minimis means, small. So if it's below a certain level, then you don't have to deal with it. Usually there's some deductible. It's got to hit a certain amount. And then hopefully if you're the seller, there's going to be a cap on how much you're going to owe if certain things happen. The due diligence, I guess, is sort of the next thing to talk about in terms of this area. And due diligence in the government context space is really a big part of what we need to go over. So certain business aspects here in the government contract space really take some time to look at. So CPARs, past performance, IP audits, investigations, any ongoing claims, SCA issues, these are the things that go into this. So I think everyone probably by this point understands what I mean by due diligence. After you do the NDA, after you get a letter of intent, you're going to dive in and start looking at the books and seeing what what's going on and how that impacts value. Bid protests that are out there, whether they're complying, whether they have the code of ethics and conduct, facilities clearances, are there foreign ownership issues, any labor and employment investigations going on. You don't want to close and then find out that there's some investigation that's going on. You want to know teaming agreements and mentor-protege agreements that are in place. And these are some of the documents that you're going to want to look at as the purchaser on these. You go through the historical statements, the income, performance information. All of this is pulled together and dropped into that virtual library that we talked about. Looking at corporate documents, minutes to make sure that they're correctly following the corporate stuff. So you always check past performance. One of the most important things in government contracting in terms of submitting a proposal and getting contracts is your past performance. So it's the single most important non-price evaluation factor. So as part of the due diligence, you're going to figure out what is the history of past performance by this particular contractor. IP, this morning as I did a tour here, we saw the intellectual property can be quite valuable. It can justify a sole source award. So what you want to do is make sure that they have the IP, they have it documented, they have the ownership correct, that either it's been R&D dollars by the company or you have this thing properly protected. And try to determine, what the value is for commercial markets. Truth in Negotiation Act. So, unlike commercial area, when you do business with the government under certain contracts, you have to tell them what it actually costs to make this, what really goes into the pricing. And it has to be current and complete information. And if you don't give that, it is a TINA Act violation. So you want to make sure that the business that is being purchased has been complying with this and the cost accounting standards and so forth. Man, there's a lot on that slide. But really, this simply deals with what happens if there's bids and proposals that are out there that have not yet been acted on. And the bottom line is if a bid has been submitted and the contract hasn't yet been awarded and there's a sale of the business, the offeror, then the contracting office can reject the bid and proposal. Miltech was a case, it was a Court of Federal Claims case. It was actually a stock sale, but the agency refused to award because of the transfer. So, a question for the contracting officer, is the offeror intact and able to honor their commitments? So if there's a bid and proposal out there, it is possible for the contracting officer to reject, but they don't necessarily have to. So that's one consideration. Novation, I mentioned earlier. So novation is the government's formal process for agreeing to let you transfer a contract as part of this asset purchase. This is a paper drill, and really sort of the biggest takeaways here are, they're in the FAR, the Federal Acquisition Regulations. There's a laundry list of items that the contracting officer has to be given to approve this. There is a novation agreement draft in there that you can use, a standard form. And it's best to talk to the contracting officer early is a key takeaway. Make sure they understand, figure out, are there any particular things they're going to want to look at. The novation doesn't happen until after the purchase. So you're going to want the seller to agree that they're going, as part of the definitive purchase agreement, they're going to agree to help you pull together all this information and get it done at the end if you're the buying company. And if you're the seller, you need to know that you're going to have to help the buyer out with this after the fact. So this attachment A in the FAR subpart 42.12 deals with this. There's practice tip, sales agreement should specify post-close obligation. Any question about novations? The lead agency, do we have a question? Okay. Sure, of course.
Thank you. Okay. Oh, I want to sing. So I thought you said on the previous slide, what I'm taking away here is you said effectively the novation is a paper drill and that there's no real risk. I think I saw on the previous slide that it's going to be issued. But then prior to that, I thought the comment or the case with Miltech was such that the agreement ultimately wasn't approved or wasn't able to transfer because the contracting officer didn't consent. So what's the space in between the consents or approvals of the contracting officer and the novation?
Sure. Miltech case dealt with a transfer and a bid was pending. Novation really deals with, he's already got a contract and he's the seller of the contract, of the assets that include that contract, and I'm the purchaser. So it comes to me, contract already exists with the government. When that happens, the government has a clause in there that says it can terminate for convenience at any time. Good for him, good for me, But once I purchase, we're going to show the contracting officer that I'm responsible. I can do this for you. I'm getting the employees, the incumbent employees that are going to do the work. Those are the same people. They're going to work for me. I've got the processes in place. I've got a cost accounting standards that are good for you. We're going to keep your technology safe, so on and so forth. You prove all this stuff, get approved, and the novation agreement is approved by the contracting officer. And that generally happens. I mean, the risk is low there. It's just something that you have to prepare for. There's a whole laundry list of these items that have to be provided. my minutes of my meetings of the board of directors and my corporate organization and so on and so forth. Things you have to show the government, but generally they get approved. Miltech was a purchase and then a bid was outstanding. And so what they determined there was no award yet. It was pending, and the government decided that they couldn't handle it, that they weren't the same. Right. So who decides? Yes, of course. Who decides this? It is actually the administrative contracting officer. So the ACO, which generally is the contracting officer administering the largest unsettled dollar amount contract. So your biggest CO is the person that takes this on for all of the contracting officers across all of your contracts, and they approve that. So there is potentially some opportunity to forum shop and get the nicest contracting officer you've got, but generally speaking, it's defined by FAR. So there's the proposed novation agreement, evidence of your ability to perform, and the contracting officer will tell you what else they want. So moving on from novations to some other government contract specific M&A issues, and I think we're still pretty good with time here. The ability to get small business set-asides is a valuable commodity, as I think this group understands. Small is determined by NAICS code, it's determined by the contract, by the SBA, but for the contractor, it's, your NAICS code, and then how many employees you got or how many dollars of revenue you have. And, the federal government sets aside certain contracts as small business. So as the purchaser, as the buyer, you need to be able to determine, what small business contracts exist, and are they going to come with us after the purchase? So if a large business buys a small business and all of their contracts are set aside for small businesses, there is affiliation. Even if it's held as a subsidiary, the revenues of the big are going to be deemed revenues of the small, and therefore it could bust the size. So what happens? You go back to that contracting officer. That agency gets credit for those small business credits for those dollars paid out to the small. But now that it's not qualified anymore, they don't get those credits. It could be that the contracting officer determines it's okay. We only have 2 years left on this contract. We're just going to continue to do it. Or they may decide, I'm going to terminate this for convenience. I'm going to re-procure this, do a new procurement and award to somebody else so we can get those credits. Important to know if that's a key area of the business, if you're going to be the buyer. So you may want a closing condition to be government approval of this contract transfer. So in due diligence, do they hold set-aside contracts? Red flags. You're going to want to look at the standard form with the set-aside box checked, look at their contracts, and then look at SAM, the System for Award Management, the registry for vendors, to determine, is this a small business, and look at what contracts they've got. And the loss of small business status can result in immediate termination, recompete, disadvantage, and so forth. And not just small. It can be status. If it's a service-disabled, veteran-owned small business that's being acquired, and the new business doesn't qualify as that, you could lose those as well. Within 30 days of a approved contract novation, you got to recertify. So this is when it's going to come up. You got to tell them that this has occurred, and that's when the agency no longer can count the options or orders pursuant to it, and has to make the decision whether they terminate and recompete. 8A is a little bit different. Does everybody know what 8A contract? This is sole source awards to 8A qualifying businesses. A different situation, really. In this instance, it is a shall. 8A contracts are supposed to be performed by an 8A concern, and really it's only if you get a waiver, a certification form going to the head of the contracting agency or authorized official, for someone to substitute in and do that work. This is a case that's out there that sort of demonstrates this. International Data Products Corporation, the Air Force terminated because IDP lost its 8A status. This is a federal circuit court case hearing an appeal from a decision of the Court of Federal Claims. The federal circuit case is 492 Fed 3rd 1317 2007 case. But, first of all, they, didn't get the contract anymore. They terminated for convenience. And the government said the successor is still responsible for all warranty obligations. So double whammy. Best to figure these things out in advance. So the old rule with regard to size status was you updated it only for asset purchase. That'd be in a novation situation. The current rule is the small business contractor has to re-represent its size status within 30 days of a stock purchase or a merger. So, you've got to tell the government when these things occur, which sort of brings us into what I was mentioning. The SBA rules concerning size and affiliation. So if everyone sort of understands affiliation, one problem, hearkening back to what I talked about, we've moved past the NDA and you like me and I like you, but we've actually gotten a letter of intent drafted, how we're going to go through this process. If that LOI is too specific, then the SBA is going to decide that you've already essentially done the sale, that it has present effect. So, unless there are big terms that are left open, then the SBA is going to consider it to be present effect. So that a purchase has already taken place, these two businesses are affiliated. So large business talking to a small business, they sign this LOI, they start going through due diligence. The big decides, hey, I really don't think I want to buy. But at this point, if the LOI was too specific, then the SBA is already going to draw a circle around all of the revenues, and that small is going to have lost its small business status. So a key point there would be to leave certain primary negotiation points open. Two cases, the SBA number, those are size protests in front of the Office of Hearing and Appeals, the SBA, and those are decisions. One found affiliation, one didn't find affiliation, and there's several distinctions. This is kind of the takeaway. If you go through the facts of both of those cases, here's the principles. If it stipulates that the price is conditional on the seller meeting certain targets, that could ultimately mean there's enough wiggle room so it's not a present effect. Conditioned on the buyer's extensive due diligence and allow for either to withdraw. That is the sort of things that you want to leave open. Announcements sometimes can impact pending bids. And this was a GAO opinion with Lockheed Martin. Actually, the site should have a 0.5 at the end. There's protests. This is a GAO protest, this B number, and they have several different protests going on at the same time. This one should be 0.5 at the end. But at any rate, the agency, the Corps of Engineers, excluded Lockheed from a task order issuance because of a Lockheed planned spinoff of its information systems business segment. And the GAO upheld this, saying there was uncertainty about the ability to perform post spinoff. So even an announcement could result in the loss and can impact pending bids. Antitrust, in certain instances, the government can object that and block a merger or sale. These are two high dollar value M&As that were blocked by DOJ because of antitrust grounds. Doesn't necessarily happen that much in small business government contracting, but when you get to the big time, it does. Foreign investment. I attended last week the North Alabama International Trade Association conference that dealt with a lot of ITAR, export control, foreign influence and control issues. So this is another area that the buyer has to consider and the seller should have in order before purchase and sale. If a foreign company is investing as the purchaser, there are things that have to be looked at. And part of that is a CFIUS review, a review of the national security implications. If you're dealing with a Chinese company that's purchasing a business, sure, everyone thinks that's something that would have to be considered. But, Canadian purchase or just an issue where employees are foreign nationals, there is transfer of technology that is implicated. So there are a couple of considerations: trade, the CFIUS review, DSS, security review, foreign ownership, control, or influence mitigation that has to be done. These are parallel processes and related, but different agencies are sort of in charge. Foreign ownership, control, investment, this is what that really means. It can be direct or indirect. And there are ways to mitigate some of these by having the owners not have day-to-day control over operations and have voting done in a particular way. ITAR, the flow of technology and defense knowledge, is considered here, and foreign national persons involved in the business. The access by them is the equivalent to transfer to another nation state. So for buyers, the key is to learn whether this is going to be a problem. Is the seller compliant? What will need to be done to continue to be compliant? Are there problems out here related to export of information? Has the target company been compliant? Part of that is determining what the products are, what the contracts are, who the customers are. And the fact that there are potential criminal liabilities and fines and debarment, which is capital punishment in government contracting, makes all of this very important. Again, past performance, something that we discussed earlier, is very important. So checking out the contractor performance assessment reporting system, CPARS, is important. Another thing, it's advisable to look at contracts that have been terminated in the past, either T for D, termination for default, termination for convenience, any cure notices or show cause notices that they've gotten. Those can impact ongoing business. OCIs, I think everyone understands what this means in the government contract world. Part of the due diligence, you're going to try to figure out whether or not this purchase is going to create an OCI. I mean, if you buy business for a particular contract or a particular skill or whatnot and bring them in, and it just creates problems with your other contracts, you want to know that at the outset. And these things sort of lead to splits. SAI split part of its business out in 2013 or thereabouts, rolling out LIDOs as a result of sort of OCI issues. Intellectual property, again, a busy slide, but the bottom line is the government usually gets broad license rights, but what you need to do, what's important in this particular instance is figuring out in that due diligence process what the government contractor has. The buyer has to analyze specific clauses in the government contracts to determine, whether or not the rights that the contractor has are valuable and protected, and if they followed the disclosure, marking, and other requirements of the contract to make sure that they have that property and that value. Even if there's no novation that actually took place, if there's just a change of name as part of a stock purchase or merger, all those who have been in the government or do business with it know there's a procedure. There's a procedure for everything in an acronym, right, for everything. So FAR talks about the change of name procedure. Very similar, but not quite as detailed as a novation agreement. And that approval has to go through. Notify the ACO of the proposal, submit the package, and get it approved. Which ultimately would require potentially a mod to the contracts with the new name and a flow down. So this is where we've gone, and I'll open it up. We've still got some time for additional questions. I know that was kind of a fire hose of, what a M&A is, what the activity that's taking place now, and some of these issues. But hopefully everyone got something out of that. And, at the end of the day, hopefully seller retires, buyer, takes care of the cleanup work. The attorneys hopefully get paid, and the employees, they just keep on working.
Quick question.
Yes, sir.
So, enforceability, indemnification, is it normal to have an escrow?
So the question, if everybody didn't catch here, is there escrow that's built into this definitive purchase agreement to deal with indemnification and so forth? Yes, there can be a number of ways to deal with that. There can be escrowed money, but after the indemnification period will then go to the seller. There can be clawback. There can be, as we discussed, earnout, and the earnout can be tied to some of these reps and warranties and indemnification as well. Sometimes, depending on the size of the deal, there is insurance that can be purchased to deal with some of this indemnification responsibility. You really don't want to be doing that for $5 million deals, $250 million deals, yes, perhaps.
What would you tell the small businesses that are bumping up against the revenue caps to maintain their status? They're small.
Mm-hmm.
They're making good money.
Right.
And if they earn a little more in the coming years, they lose their status.
Yeah, and those things change. The Runway Act, as we know, changes some of the look back times, and the government changes the standards from time to time. I think as a business person, you want to grow your business. Yes, it is advantageous to be a part of these small business programs, but the whole idea with the program, of course, is to have those companies go out there, give them the assistance they need to grow and get larger. So I'd say that during that period of time where you have set-asides, where you're entitled to these small business set-asides and programs, look for teaming partners. Some of the stuff that I sort of rolled through there, mentor-protege agreements, joint venture agreements. A lot of bigs are looking for smalls that have status that they can team for opportunities on, develop relationships there. I also see, sort of small businesses get too big, and then they have to turn around and look for a small to front for them, to team with them so they can keep going after those opportunities. There's, a big difference between small, just a little bit too big to be small, and, the Lockheeds, Boeings, Raytheons of the world. So prepare early. If you're someone who has built up a business that's valuable, has, intellectual property, good contracts, things like this, get your house in order now. Get your children's cars out of the company and so forth. Make sure your corporate books are in order. All these things are going to make the due diligence process better. Go to industry days and summits and things to bump up against the bigger companies if you're interested in a sale. And, I see a lot of people sell and stay in charge of a business unit. And part of the negotiation can be autonomy and how you become the director of this business unit that's part of a big company, but you still maintain some control. Yes, sir.
Okay. One of the most common questions I get in the small business office at the lab is from large businesses who have bought out a small business that held SBIR contracts. Now I know that I was hoping you can touch on that for the audience and whether or not they are eligible for future contracts in the different phases, because I know the answer is different, and I know the audience would probably find that very relevant.
So can you be, if a big purchases the small, can they continue to do the small business work?
Correct. Under an SBIR.
Yeah, I don't know that I can answer that on the spot. I'm
Okay.
sorry. I mean, I think the answer probably is it depends. The phase for one, and frankly, I don't know that I can answer that here.
Okay.
I could go research it and come back to you.
Very expensive.
I guess that's another disclaimer I should say. You know, none of this is legal advice for your particular business. Okay. Yes, ma'am.
So being part of a decent or large firm, right, you probably see a lot of deal flow.
Yes.
So do you have any insight in, you talked a little bit about the sizes, right, of companies that are changing hands and how much private equity is taking on
Right.
kind of middle markets, but what do you see? Is there anything interesting that you see or a high volume of activity between certain sectors, like our pharma companies taking on middle market cyber companies? Kind of what strategic or big picture trends do you see happening in M&A and activity from your perspective?
That's a great question. So first of all, I'm new to the firm. Womble Bond Dickinson is a firm that's been around for quite some time and it is large. I've been with them since September. So that's one thing. And I focus my practice in the government contracting space. So I know I've got partners, in the energy sector, in the pharmaceutical sector, others that see that area of the business more. In the government contract space, I think we see a lot of strategic acquisitions. So companies that want to grow in the cybersecurity space. So they are looking for particular people that have particular relationships with an agency or drilling down further with a contracting officer. They chase work. So they see a potential opportunity that's going to come out sometime in the future. So the strategic purchases with, bigger contractors, that's sort of it. And they are looking to sort of the lower middle to small businesses. There's a lot of sort of pickups in that area. Private equity, was big into, I'm talking about, private equity dollars coming out of Chicago, DC, and so forth. Was coming into the large and the, larger middle, and now, is focusing on middle, and lower middle. I mean, the smaller end, because it's still seen, particularly in, space and missile defense and in some of those areas, is a good investment of their dollars rather than parking the dollars elsewhere. The world is complicated, and when it becomes more complicated and scary, sometimes those investments are ones that are paying off. So I would say cybersecurity, particularly with the CMMC 2.0 rollout, being something that all government contractors are going to have to deal with, hypersonics, drone, UAS, and missile technologies, all of which, has to be controlled by something. So the tour we did today, in terms of signal and so forth, important areas. And, there are a number of acquisitions that are IP related, very particular look at particular things that can plug in and help. Does that help? Yeah. Melissa, are we towards the end of anybody else have any questions? I will be hanging around for lunch and can answer more questions. My pleasure. Thanks.